we've got a question that was asked by Jaconia, if I'm getting her name right. She says, we recently purchased a property from a late estate. The offer to purchase and all other documents were signed. We were told to pay the lawyer's fees, and a home loan has subsequently been approved. We are 95% through from a process perspective. This is what she says. The problem that she faces now is that there was no will made out by the deceased, and the executor who put the property up for sale recently described that there's a hold-up in the process because certain family members of the deceased have not provided their consent for the sale of the property. We are now being given the runaround. She wants to know what are her options. Bruno?
Sure. So deceased estates, and I often say this, it's not always the most pleasant experience from a purchasing perspective. There's a lot of uncertainty. People that are dealing with their estate aren't necessarily the people that were involved with the family members, so they're disconnected to a certain degree. Some of them professionals, but with a lot of work to do. But then in addition to that, and having this professional that's disconnected, you then have to deal with the master's office, which is then a state institution that is very disconnected because they're supposed to have oversight of this entire process, kind of guide everyone on what's supposed to be done and look out for the best interests of the heirs and beneficiaries and the like. But I mean, it's regretful, but the master's office is in shambles. There were reports just before COVID hit that there was going to be an audit. They had taken, if I'm not mistaken, certain pieces out to see what was happening. There were backlogs. And then when COVID hit, things just became worse. And I mean, on the side of my practice that deals with trust registrations, I mean, there can't be a few weeks ago, the master's office in Joburg issued a directive saying that they're not registering any trusts for this year. Sorry, this must have been maybe 2 months ago, but it's just an example. And not registering any trust for this year because they've got such a backlog from last year. And we're still struggling with it. I mean, we've had to go to other master's offices. So long story cut short, it's a very similar process when it comes to deceased estates. When you buy, an executor is entitled to put up the property for sale, right? That is the executor's job. But now you need to think on the circumstances under which this actually arises. An executor would typically only put the property up for sale if there's no liquidity in the estate. Reason for this is the heirs a lot of times would be happy to take it even if there's no will and they die intestate. There's a property and sometimes the heirs go, great, I'm happy, let's co-own it or give it to that person, I'll take that that other property or whatever the case is. Now in this instance, one of two things is happening. Either there's not enough money, so the property has to be sold in order to cover the debts, or there's a fight where some want it sold, some don't want it sold, and the executor's only option is to liquidate, right? So now the executor is working against the heirs of the estate. And this does cause delays because they typically, if they sign everything off, you take it to the master, you get the consent, there you go, L&D account, and it gets sold, right? Liquidated and the money gets paid out. Now you need to go against the heirs. You need to go to the master and ask for permission, motivated. And now you're asking the professional to do this at a master's office that isn't particularly efficient, with resistance from beneficiaries. And we don't know the level of resistance. Maybe there's real justification. I mean, there's even possibilities that this might go to court and there might be some sort of challenge. So it's very important. Now, obviously, like this is hindsight, but very important when you enter into these type of contracts that you've got suspensive conditions that allow certain exits at certain points. There is a level of due diligence I even suggest when it comes to deceased estate, so you can determine where you are in the process, and that your holding costs are minimal, and that there's exits where you haven't paid anything that you can't get back. Obviously, now that's not possible. So now you're looking at what to do moving forward. There is a principle in when it comes to sales that a person would have to pass transfer within a reasonable time. So there's an argument now as to what is reasonable. So there is a point in this process where you can say, listen, executor, this has gone from reasonable to unreasonable, and I want to exit, I want to cancel because you're in breach, you haven't been able to transfer, so give me all my money back, and I can actually sue you for damages, but let's just agree to walk away. Insofar as forcing the sale is concerned, you're going to struggle because the executor doesn't really have much of a choice usually, and they need to follow due process. So you're not going to get a court to simply overlook it. You might speed the process along, but you're not going to get them to ignore due process. So it's either cancel or kind of try help push it as fast as possible, but be patient.
Thanks, Bruno. And the last question was asked by Robin. Robin says, if I'm the executor in a will, can I wind up the estate myself without being compelled to use an attorney? Note, I am not related to the testator. Bruno?
Yes, you can. As long as you know what you're doing, you can.
Cool. Cilna, do you concur?
I concur fully.
Well, Robin, there you go. That's your answer. And if you need more questions and you don't feel compelled, you may contact Bruno and you may contact Cilna as well.